right, everybody, welcome back to the review of the 1-4 residential sales contract for resale. We're going to cover paragraph 8 through 11 today. So let me jump right into this. Paragraph 8. Paragraph 8 of the contract reads as follows. Broker fees. All obligations of the parties for payment of broker's fees are contained in separate agreements. This is just an acknowledgement that there are fees that are being paid, but they're contained in separate agreements, meaning your buyer rep agreements and your listing agreements. Pretty self-explanatory. So moving on to paragraph 9, closing. So this paragraph reads as follows. A, the closing of the sale will be on or before, and then you insert a date, or within 7 days after objections made under paragraph 6D have been cured or waived, whichever date is later. That's defined as the closing date. If either party fails to close the sale by the closing date, the non-defaulting party may exercise the remedies contained in paragraph 15, which we'll go over in our next video. B, at closing, seller shall execute and deliver a general warranty deed conveying title to the property to buyer and showing no additional exceptions to those permitted in paragraph 6, and furnish tax statements or certificates showing no delinquent taxes on the property. 2. Buyer shall pay the sales price in good funds acceptable to the escrow agent. 3. Seller and buyer shall execute and deliver any notices, statements, certificates, affidavits, releases, loan documents, and other documents reasonably required for the closing of the sale and the issuance of the title policy. 4. There will be no liens, assessments, or security interests against the property which will not be satisfied out of the sales proceeds unless securing the payment of any loans assumed by a buyer, and assumed loans will not be in default. And 5, if the property is subject to a residential lease, seller shall transfer security deposits as defined under section 92.102 of the Texas Property Code, if any, to buyer. In such an event, buyer shall deliver to the tenant a signed statement acknowledging that the buyer has acquired the property and is responsible for the return of the security deposit and specifying the exact dollar amount of the security deposit. So let's go back through this, all right? First part is pretty self-explanatory. The closing date will be on or before a specific date or within 7 days after the objections made under paragraph 6D have been cured or waived, whichever one is later. So you have the closing date, but if there's objections to title and those objections were cured or they were waived, all right, then you can have up to 7 days after that for closing to occur. It's whichever one of these dates is later. And that if either party fails to close the sale by the closing date, the non-defaulting party can exercise the remedies contained in paragraph 15. So we will cover paragraph 15 in our next set of videos, or our next video in this series. So we're not going to address it now, but just know that if you do not close by the closing date, then the non-defaulting party can exercise those remedies. The second paragraph talks about what's going to happen at closing. So some of these are real simple. There's a couple of highlights I want to point out though. But the first one is seller shall execute and deliver a general warranty deed conveying title to the property to the buyer and showing no additional exceptions to those permitted in paragraph 6. So they are not allowed to issue a special warranty deed. That's not what is inside of this contract. This contract requires a general warranty deed. They'll provide that, and they'll also provide tax statements or certificates showing that delinquent taxes on the property are non-existent. We'll kind of link this one to number 4 for a second, that if there were delinquent taxes, then those delinquent taxes would be paid out of the sales proceeds, and so there is that ability. Number 2, buyer shall pay the sales price in good funds acceptable to the escrow agent. This one seems pretty self-explanatory, but I want to highlight one important part of that, and that is the acceptable to escrow agent part. So if your title company does not accept wires, as an example, then your client cannot wire those funds into the title company. They have to be funds that are good and acceptable to the escrow agent. So a lot of title companies are trying to move away from doing cashier's checks. They're trying to push towards doing wires. And so certain title companies, or all title companies really, are entitled to have their own internal policies. And so if they do not want to accept cashier's checks and require wires, they can do that. And your client, as the buyer, does not have the right to say, well, no, I want to bring a cashier's check. You have to take that. It's not the way it works. It has to be good funds that are acceptable to the escrow agent. So just remember, ask your title company up front, what kind of funds do you want, funds from the buyer in? Can they be a wire? Can they be a cashier's check? A briefcase full of money? How is it that you want it? And when you're picking a particular title company that you want to work with, and they're going to be kind of quote unquote your title company, that would be a good question to ask, because we want some variety to make deals go easier if possible. Number 3, seller and buyer shall execute and deliver any notices, statements, certificates, affidavits, releases, loan docs, and other documents. So basically, both parties will execute whatever docs are reasonably required to execute the loan and the sale. All right. There's no situation here where they get to, bounce out of that or not be able to do that. So, all right. For the next part, states there will be no liens, assessments, or security interest against the property which will not be satisfied out of the sales proceeds unless securing the payment of any loans assumed by buyer and assumed loans will not be in default. So this is where we get the idea that the title company is going to pay off any taxes that are owed. They're going to pay off any liens that are outstanding. They're going to pay off any HOA fees that are due, capital assessments, anything that would go against the property that the new buyer would get stuck with is going to be satisfied out of those sales proceeds. The only exception to that would be if the buyer is assuming a loan, and that loan, it can't be in default. So for example, if you were assuming the loan, if a buyer was assuming the loan of a seller, and that loan, let's just say, was $5,000 in default, they're going to take $5,000 out of the seller's proceeds and satisfy that $5,000 default so that the assumed loan is all up to date once closing occurs. And then number 5, if the property is subject to a residential lease, seller shall transfer security deposits as defined under the Texas Property Code 92.102, if any, to buyer. In such an event, buyer shall deliver to the tenant a signed statement acknowledging that the buyer has acquired the property and is responsible for the return of the security deposit and specifying the exact dollar amount of the security deposit. Again, this is a requirement of the property code that it's transferred, and we do have a Texas Realtors form, which is a notice to the tenants that ownership has changed. Moving on to paragraph 10, possession. Let's read through this and then go over it. So 10A, buyer's possession. Seller shall deliver to buyer possession of the property in its present or required condition, ordinary wear and tear accepted, upon closing and funding, or according to a temporary residential lease form promulgated by TREC, or other written lease required by the parties. Any possession by buyer prior to closing or by seller after closing, which is not authorized by a written lease, will establish a tenancy at sufferance relationship between the parties. Consult your insurance agent prior to change of ownership and possession because insurance coverage may be limited or terminated. The absence of a written lease or appropriate insurance coverage may expose the parties to economic loss. And then 10B reads leases. 1. After the effective date, seller may not execute any lease, including but not limited to mineral leases, or convey any interest in the property without buyer's written consent. And 2. If the property is subject to any lease to which seller is a party, seller shall deliver to buyer copies of the lease or leases and any move-in condition form signed by the tenant within 7 days after the effective date of the contract. So let's go back through this. So at closing, all right, the seller is going to deliver to the buyer possession of the property in its present or required condition. So present condition meaning as is, or a required condition meaning if you have some repairs or something that you're wanting them to do. All right, ordinary wear and tear is allowed. And then it's either going to be upon closing and funding or according to a temporary residential lease. All right, so upon closing and funding, so possession only occurs once you close and fund. And so to be clear, the closing portion is where everybody shows up, signs their documents, and everybody's excited. And then the funding is when the lender, two parts of funding. When the lender approves the documents and tells title that they can release the funds, or if it's a cash deal, once you close, you usually have funding within less than an hour when the title company is satisfied that all the documents are appropriate and they will fund it. So this is why in some instances, if you close, for example, on a Friday evening at, let's just say 4 p.m. and it takes you 45 minutes to close and the docs go out, and by 5 o'clock, the lender has the docs, but you know what? They went home, they're done for the day, and they're not going to review those docs until Monday. Guess what? Possession is not going to occur until Monday when they have time to review the docs and then authorize the title company to release the funds. I'll give you another example. Have a commercial deal going on right now inside the brokerage where it is subject to a court approval, meaning that we will close, and then 6 days after we close, the judge is going to sign off and approve the sale. It's an estate sale. And so once the judge signs off, then the title company can release the funding. All right, so that's going to be an example of a closing, and then you have to wait a week before funding, so possession cannot occur until that funding portion is in play. So closing or funding, or according to a temporary residential lease form promulgated by TREC. So TREC has a seller's temporary residential lease, and they have a buyer's temporary residential lease to handle situations where maybe the buyer moves in early, or the seller moves in, leaves a little bit later than the closing. So use one of those, or another written lease required by the parties. All right. And then it creates a little note that says any possession by the buyer prior to closing or by the seller after closing which is not authorized by a lease will establish a tenancy at sufferance relationship between the parties, meaning that you are residing there but don't have a legal right to do so, meaning you could be subject to eviction and things like that. And then a nice big bold print, it talks about consulting your insurance agent prior to ownership and possession, because if you don't, you could have a lapse in coverage. So there have been instances. For example, I'm going to use the closing on Friday example, where closing occurs on Friday and the seller set their insurance to be done on Saturday. All right, day after closing, that makes sense. Well, if the funding hasn't occurred, meaning possession hasn't taken place before the weekend's out and they're waiting till Monday, if that home catches on fire on Sunday and the buyer's insurance hasn't kicked in and the seller's insurance is over, guess what? You now have a property that is burned to the ground and there was no insurance on that property whatsoever. And in that case, all of a sudden, the seller can't perform anymore, all right? Because the seller has to deliver the property in its present or required condition. And if they can't do that prior to closing and funding, you have an issue. So in that case, the seller would be screwed because they have no insurance coverage. So no money coming to them. Their mortgage lender would probably be really, really upset. And the buyer would probably be really upset because they signed the papers and closed, and guess what? Now they don't have a house to move into. Same thing, if you have no lease in place, all right, it could open you up to economic loss because you'd have to spend money to evict somebody and get them out of there. So always make sure that your sellers keep their insurance in place until after closing and funding. All right. The reality of paying for insurance for an extra 1 or 2 or 3 days or even a week is not all that much money compared to the risk you take by not having coverage. So I always tell my sellers, wait till you close, wait till we fund, and then after we have funding, then call your insurance company and tell them to shut off the insurance. Don't do it ahead of time. Don't try to pre-plan that. Bad idea. All right. So that's that section. So then we're going to move on to leases. All right. So once we go under contract, all right, on a property, the buyer has what they call equitable interest in that property, meaning the seller now loses the right to just do whatever they want with their property. All right. Equitable interest is what keeps sellers from ripping out all the nice cabinets or nice countertops or nice fixtures and putting in junky fixtures or junky countertops after the contract has been signed. The buyer has equitable interest and has a right to have a say-so about what happens with the property at that time. So we just want to make sure that we're doing that and that the sellers understand they can't do anything else. The second portion of this is that if there's a lease in place, all right, the seller has to provide a copy of that lease to the buyer within 7 days. All right. So I have heard instances where sellers or listing agents say, well, we don't have to give you copies of the lease, or we don't have to do this, or we don't have to share that with you. We don't have to share condition forms, or we don't have to share anything about the tenants with you. That's not true. You do. You have to share the leases, you have to share the condition forms, and you have to provide them within 7 days. Not providing them within 7 days technically puts you in default of the contract, and the buyer could enact their remedies under under the default paragraphs. So make sure that you're following the rules. Make sure you're providing copies of the leases, condition forms, and then for buyers agents, when you have buyers who are purchasing property, make sure that they understand the leases. All right. Now, if it's a lease that you have no experience with, it's not a Texas Realtors lease, You have no business explaining the lease, the ramifications of the lease, or anything else to them. And if they're seeking legal advice about the validity of a lease, you need to refer them to an attorney, but you need to make sure that they have copies of the leases, that they have copies of the condition forms, and that they have thoroughly done their due diligence on the fact that there's a lease. In the state of Texas, a lease carries with the property. So if your lease is, good for another year, just because a property is sold doesn't mean that lease goes away. So buyers really, really need to be aware of that and make sure they're doing what they need to be doing. All right, so that's a review of the closing section. We're going to move on now to number 11, which is going to be special provisions. So special provisions, for those of you that have been licensed for a while, will be the section that you recall continues to get smaller and smaller and smaller. At one point, paragraph 11, special provisions made up about a third to a half of the page. And over the years, with every contract revision, it gets a little bit smaller, and a little bit smaller, and a little bit smaller. And the reason being is they want us to stop writing a bunch of stuff inside of this area. All right? Let's read through this real quick. Number 11, special provisions. And by the way, I realized that I previously said 10 was closing. The paragraph 10 was possession. But anyway, number 11, special provisions. Insert only factual statements and business details applicable to the sale. TREC rules prohibit license holders from adding factual statements or business details for which a contract addendum, lease, or other form has been promulgated by TREC for mandatory use. And then there's this big old blank where you can enter in a bunch of stuff. All right. So what can you put in here? Well, the answer is very little. All right. Most transactions do not require you to put anything inside of special provisions. To be clear, it states very clearly right in there in the paragraph that TREC rules prohibit license holders from adding factual statements or other business details for which a contract, addendum, lease, or other form that's promulgated by TREC for mandatory use. So do we put things like the fridge will stay with the property, or seller is giving to buyer washer and dryer? Do we put that in section 11? No, we don't. We use a non-realty addendum. All right. There's a rule. All right. It's TREC rule 537.11 B5. All right. And this is what that rule states: that a license holder may not draft language defining or affecting the rights, obligations, or remedies of the principals of a real estate transaction, including escalation, appraisal, or other contingency clauses. All right. So you cannot write things in here. One of the things that was in here a few years ago that was very prominent was escalation clauses, where buyers would say, hey, whatever your biggest offer is, we'll add $1,000 to it, or we will go in $10,000 over any other offer, or these other escalation clauses that get agents in trouble because that is practicing law. And in the state of Texas, it is against not only our code of ethics as realtors, but it's against the law for us to practice have the unauthorized practice of law. Sorry. So unless you're also an attorney, you cannot draft language in here that affects the terms of this contract. And one of the biggest ones I see is other than the unauthorized practice of law, I see a lot of people that use this section for things that we already have addendums for. All right. So what can you use this for? Well, there are certain things that you might be able to use in here. So for example, if the number of sellers can't fit in paragraph 1, maybe you're going to add additional sellers into special provisions. If you're doing a 1031 exchange and you need the statutorily required, that's not statutorily required, but the required language that is involved in a 1031 exchange, you could place that language here in special provisions. All right. Are you going to place that? Are you going to put in here things like seller to repair broken tiles? No, because that's not where stuff like that goes. All right. I've also seen people put things in here like, seller will have house cleaned prior to move out. That's not where this goes. That would go in the section where it talks about whether you're taking the property as is or as is with certain treatments or treatments or repairs. All right. So the reality is most transactions you will put nothing in here other than NA, meaning it's not applicable. All right. And if you're going to put something in here, stop before you do it and ask yourself, is there a form for this? Is there an addendum that I can use for this? Or is there a other promulgated form that I'm supposed to use? And if there is, use that. If there's not, then ask yourself, by putting whatever I'm about to put in here, okay, changes the terms of the contract, all right, am I bordering on unauthorized practice of law? And if you are, you're going to want to reach out to your broker for some guidance to make sure you don't step over into that area. Putting things in here that change the terms of the contract, even if you don't mean to, can result in a lawsuit where you're standing in front of everybody trying to defend your actions when you really didn't mean to do anything, but that's not going to suffice for, doing something you're not supposed to be doing. So please don't put things in here that would be considered the unauthorized practice of law. Please don't put things in here for which we already have addendums or leases or other forms. All right. And if you're going to put something in here and you're not sure, talk to your broker and get clarification from them. So that's it for this section. There's not a lot to explain about it. It's mostly to explain what not to do with it. And so that is going to conclude our review of paragraphs 8 through 11 of the 1 to 4 residential contract for resale. Moving on to in the next video, we're going to go ahead and cover paragraph 12 and forward.